Okay, let's go ahead and get started here. So my name is Matthew Stubenberg. I'm the IT director and a staff attorney here at the Maryland Volunteer Lawyer Service. And I've been doing expungement law now for almost 3 years. And today we're going to go over the new expungement law that takes effect October 1st, which is called kind of colloquially as the JRA expungements or Justice Reinvestment Act expungements. Now, before we go ahead and jump right into that, we're going to go ahead and take a look first at some changes that are coming into effect for regular expungement law. And I'm going to pause here for a second to say that the regular expungement law is not going away. There's just going to be 2 avenues now to try to expunge something. But today is just another avenue. It's not replacing any of the old expungement law. So before we jump into the new JRA expungements, under the regular expungement law that everybody knows and loves, 10-105 criminal procedure, there's a new piece going into effect which solves the marijuana weight problem that we've all had. So if you all recall, marijuana possession, if it's less than 10 grams, was decriminalized in Maryland a few years ago. And expungement law allows crimes which are no longer a crime today to be expunged. Now, we've run into this issue a lot where somebody would have a marijuana possession case and we wouldn't be able to identify how much marijuana they were in possession of. Was it more or less than 10 grams? It would lead to hearings, which would lead to a lot of investigation and trying to find out exactly how much weight there was. The legislature listened and they added this piece to the statute that says, so long as the marijuana case has been more than 4 years old, the amount of marijuana doesn't matter. You can get it expunged. So this is a big benefit to us. So now all marijuana possession convictions are eligible for expungement under the regular expungement law, so long as it's been more than 4 years. Now I will say that this still only applies to possession, not intent to distribute, nothing like that, only possession. And it's still only marijuana. It's not other CDS, heroin, anything like that. It's only marijuana. But it is still a step in the right direction here. So no longer does the amount of marijuana matter. Now, I do want to mention something else because I've seen this come up several times. Paraphernalia related to marijuana was decriminalized in 2016, last year. But I've noticed that a lot of people don't realize this, and we sometimes get objections to it. So this was actually an interesting legislative move. The legislature passed a bill that decriminalized marijuana paraphernalia, which makes sense since marijuana was already decriminalized. And Governor Hogan actually vetoed it, and the legislature overrode his veto, passing the law. So paraphernalia as it relates to marijuana is decriminalized, which means it falls under that provision in the expungement statute that says, so long as a crime is no longer a crime, you can get it expunged. So if you come across a case with, a conviction on marijuana possession and a conviction on marijuana paraphernalia, that is eligible for expungement. The paraphernalia is not going to stop it. So I just wanted to make sure everybody's aware of that because we've seen that kind of across the board a couple times. Okay. And I would like to encourage everybody that if you have any questions, feel free to write them into the chat. I'll answer them as they come up. I can see them on my other screen here. And if something's confusing, please just tell me to slow down or go over it. Okay, so what does JRA stand for? It stands for the Justice Reinvestment Act. Now, there's a lot included in the Justice Reinvestment Act. Expungement is just a small piece of it, but it's the piece that we're going to be talking about here today. So it was actually passed last year in 2016, but they decided to wait to have it take effect until October 1st of this year. So everything we're learning today doesn't actually go into effect until 2 weeks from now or a week from now on October 1st of this year. Now, a general overview of the Justice Reinvestment Act expungements that I'm going to be talking about basically says that it allows for certain convictions to be expunged after a long waiting time. The JRA is only related to convictions, trying to expunge convictions. So if you have a case that's completely null pros, that's only not guilties, doesn't have any guilties, and you're trying to follow these steps under the JRA that I'm going to go over, you're doing something wrong. The JRA is only for convictions. So what convictions are actually eligible? So there's over 40 convictions that the statute allows to be expunged, which is a good thing. A lot of them are very minor and will probably almost never come up in practice, but there are some big ones in there, and I put the big ones right here. Assault second, trespass, CDS possession, and that's all CDS possession, not just marijuana or anything, but it is only possession. It's not intent to distribute, it's nothing like that. It's only possession. Paraphernalia, and that's any CDS paraphernalia. CDS, of course, is controlled dangerous substance or drugs. Prostitution, gambling offenses, theft, tax claims, real estate. There's a couple of real estate crimes that's in there. Contempt, hindering, and then there's attempt, conspiracy, or solicitation of any of the other charges. So if you have attempted trespass, that's also covered. Now, I will say that all of these convictions are eligible, but only the misdemeanor version of these convictions. Now, a lot of these convictions can only be misdemeanor, so that's usually not going to be a problem. Almost every CDS possession case is going to be a misdemeanor. If it was felony, it would be intent to distribute, something like that. So almost every CDS possession case is going to be misdemeanor. The biggest problem I can see is with theft cases. Theft under 500, I believe, is a misdemeanor. Over 500 is a felony. And so there are going to be these tiny little caveats that we're going to have to work out as we go through this. But the JRA expungement only applies to misdemeanor convictions, not felony convictions. And if you'd like to see the full list of convictions that are eligible, we have gone through the statute and parsed out what all of the different convictions are. And they're on our website. I'm going to put them into the chat box here. And that is a list of all of the convictions that are eligible if you're curious and interested in more than just the popular ones. All right, so those are the convictions that are eligible. But there are a number of fairly daunting restrictions that are attached to a JRA expungement. And the first one here is a time restriction. And the time restriction here is very onerous. So for almost all the convictions, and I'll go over which ones don't apply here, for almost all of them, you have to wait 10 years from the end of any probation, sentence, parole, or mandatory supervision before filing. Now, you'll remember with normal, regular expungement law, it's usually from the disposition date. Any waiting periods that you might have with regular expungement law is usually from the disposition date. That is not the case with this new JRA expungement. It's 10 years from the end of any probation, sentence, parole, or mandatory supervision. So if a person is convicted of CDS possession and receives 1 year probation, they have to wait in practice 11 years before filing for expungement. Now, it's 10 years for almost all of the convictions that I showed you before, except for 2 of them. And those 2 are assault in the 2nd degree, and then any crime that is classified as a domestically related crime. For those 2, you have to wait 15 years on top of any probation, parole, or mandatory supervision or sentence. So what is a domestically related crime? It's a provision in the statute, not in the expungement statute, a different statute, that allows the state to basically request that a certain conviction be connected as a domestically related crime. They have to prove that there was some relationship between the defendant and the victim, and then the judge has to actually rule on that and find that there was a domestic relationship and the crime was domestically related. In theory, this could apply to any crime, but usually it applies to a very small subset of crimes like assault or some kind of trespass cases. Now, if you take a look in the case notes on the bottom of a case in case search, usually it'll tell you if there has been a motion put in to consider this domestically related. It's the best way so far I've been able to determine how to find out if a case is technically domestically related. You might also want to ask your client, was the suspected victim in this case related to you? Was there some kind of domestic relationship going on, or was it just somebody outside of that? But if any crime can technically be considered or classified as a domestically related crime. So if it's one of those or assault in the second degree, all assault in the second degree, there's a 15-year waiting period on top of any sentence or probation. So the time restrictions are extremely long. On top of that, we unfortunately have a kind of reemergence of the subsequent conviction rule. Now, if you've been following expungement law for a while, subsequent convictions were part of the law a few years ago with normal expungement law, and they finally got rid of it except for a small subsection with probation before judgment. For the Justice Reinvestment Act, they've decided to bring it back. And what it says is you cannot have any subsequent convictions during the time period stated in the last slide. If there is a subsequent conviction, it locks in that original case. And I have an example of this if that sounds confusing here. But first I want to go with during the time period stated before. So if you have a trespass case from 1995 that's a conviction, and you have 1 year of probation on that, you can't have had a subsequent conviction within the next 11 years. So you have the 10 years and then the 1 year of probation. So you have to review that client's record for the next 11 years to see if they have a subsequent conviction. Now, it's only convictions that they're looking for, subsequent convictions. If they have a subsequent case that was null prost or they were found not guilty on, something like that, that's fine. It's only subsequent convictions. If that subsequent conviction, it doesn't have to be related, doesn't have to be the same crime. If there is a subsequent conviction in that time period, it locks in that original case. Now, the one exception to that is if that subsequent conviction is otherwise eligible for expungement. And so let's say you have a trespass case in 1995, and then 5 years later, you get another trespass case, also conviction, in 2000. Well, trespass is one of the JRA eligible convictions. And so it won't lock it in. What it does is it extends the time period. Basically, you can't get that original case expunged, the first trespass conviction expunged, until the subsequent conviction becomes eligible, which would be 10 years from that date if there's no jail time or probation. And so what it can do is toll the time significantly. I have an example here of what that looks like if it sounds kind of confusing. So let's take kind of a sample client here. Let's say they have one case in 1995. It's a trespass conviction. They were found guilty, and they got 2 years of probation. Then 11 years later, they were found guilty on CDS, not marijuana. They didn't get any jail time for that one. And then almost 8 years after that, they were found guilty again on assault in the second degree, and they received a 1 year probation. So if we analyze this just using subsequent conviction and the time restrictions, what we'll see here is that, so we look at the case one from 1995. They have 2 years of probation, so we have to look at the next 10 years plus 2 years of probation, so the next 12 years. So that would put us at 2007. Unfortunately, we can see that they have a subsequent conviction here, case number 2, in 2006. But CDS possession is one of the eligible convictions under the Justice Reinvestment Act. So because it's eligible for expungement, but it's not eligible yet. You have to now analyze that case. So from case number 2, it's from 2006. There's no jail time, no probation. So it'll be eligible 10 years after 2006. So that puts it at 2016. So now we have to see if there's a subsequent conviction between 2006 and 2016. We take a look, and unfortunately there is. Just before the end of that 10 years, they picked up another conviction for assault second with a 1 year probation. Now, unfortunately, assault second is that kind of that bad one that has a longer waiting period. So because of this case number 3, which assault second is covered as one of the eligible expungements, but it has a 15-year waiting period, and there's the 1 year probation. So if we add all that up, 2031 is when assault second will become eligible. And when that case becomes eligible, it'll make case number 2 eligible. When case number 2 becomes eligible, it'll make case number 1 become eligible. So unfortunately, if this was the client that sat down in front of us, there is nothing we could expunge from this person's record until 2031. And that's assuming that no other convictions, the client doesn't pick up any other convictions up till 2031. So I suspect that this will unfortunately hold back a lot of our clients because for some of our clients, it can be very difficult to not pick up a conviction over the course of 10 to 15 years. And even one conviction can then mean you have to wait almost another decade before expunging your record. So this is kind of a worst case scenario of how the subsequent conviction rule would come into effect. Okay, so there's a few more restrictions here. The unit rule and the pending case rule. So these are the same from regular expungement law. All of the charges in a case must be eligible in order for there to be expungement. There is no partial expungement. So if you're trying to expunge individual charges out of a particular case, you can't do that. It's the same as regular expungement law. It's either the whole case or nothing. And there is also the pending case rule. So if your client is a current defendant in a pending criminal proceeding, there's nothing that can be done. They have to finish that criminal case before filing for anything. Regular expungement has that rule, so does JRA. So if you need a refresher on kind of what the unit rule looks like, it basically, if you have to look at all of the charges, and if one charge does not fall into something that's eligible for expungement, that whole case is locked in. So if we take a look at case number 1 here from 1992, this person was convicted of CDS, not marijuana, and burglary in the same case. Burglary, well, CDS, not marijuana, is one of the eligible convictions under the JRA expungement statute. Burglary, however, is not. And so case number 1 cannot come off because of the unit rule. Now, if we take a look at case number 2, we see there's a guilty on trespass. Trespass is one of the eligible convictions under the JRA expungement statute. Then they have a null pros, or a nolle prosequi, which means the state dismissed the case or declined to prosecute on assault second. Case number 2 can be expunged. The null pros won't lock it in. It's only because a null pros is going to be eligible for expungement under the regular expungement statute. So case number 2 can come off. So it's very similar to regular expungement law when it comes to the unit rule. Okay, so this is a new addition, the judicial discretion and victim notification rules under this new statute. So under a normal regular expungement, under the old regular law, usually whether or not a person is entitled to expungement is pretty binary. Either they're eligible or they're not. There's not a whole lot of discretion, if any, for the judge to deny it on anything other than the statute itself. The JRA kind of adds some discretion for the judge. The judge, in determining whether or not a client or whether a case should be expunged, analyzes that and has to come to the conclusion that a person is not a risk to public safety and that the expungement would be in the interest of justice. Now, it's not clear exactly what facts are relevant to this, when this will become a problem. My guess is it will only be an analysis when there's an objection by the state, but we need to see how that plays out. But this does allow the judge to deny expungements that otherwise are eligible under the statute for anything kind of basically that they find is in the interest of justice or risk to public safety. So you might want to inform your client of this. Don't get their hopes up that this is a guarantee or a lock-in like normal expungement. If they have a very lengthy record, if it's fairly recent, if they have something else that might look bad overall, there is a chance that it could get denied for some other reason. The other big piece of this here is that the victim in the case receives notice of the expungement and has a right to offer additional information relevant to the expungement petition. This is something brand new that doesn't have any correlation to normal expungement law. So now, and this is only in cases where there is actually a victim noted in the case file. But they will get service of the expungement, and they will get instructions on how to object to the petition. Now, exactly how they object and what information is relevant we're unsure of at this point. But what that means is, if your client was involved in a messy relationship and they don't want anything to do with the victim again, or there's still a lot of animosity even 10 years later, they should be made aware that the victim is going to have a chance to object. And if they object, there's going to be a hearing, and then you're going to have to prove that the client's not a risk to public safety and the interest of justice. So it is something that the client needs to be informed about, that this is a potential that the victim could come back to give additional information. All right, so that's pretty much the JRA expungement law. We're going to go over a few examples, and there's some major changes to the forms that are used under this new law, and then actually changes made to the forms under the old law as well. So first, let's take a look at two sample clients here. So here's client number one. They come in, you look up the record, they only have two cases. Both cases are convictions. So case number one is from 1992. It looks like a CDS possession, not marijuana, which is one of the eligible JRA expungible cases or convictions. They didn't get any jail time or probation, and they were also charged with murder in the first degree, but they beat that charge. They got a not guilty. Then they have a second case, case number two from 1995. Looks like a conviction on trespass, and they got 1 year of jail time. So I'll go ahead and let everybody kind of just look that over and see if they have any questions, and then we'll go over that. Okay, let's go ahead and analyze this case here. And so if we take a look at case number one, we see it's a conviction for not marijuana, CDS not marijuana, which is one of the eligible convictions, is CDS possession. They didn't get any jail time, so we have to take a look at the next 10 years to see if there's a subsequent conviction in that 10 years. We take a look, we notice there is a subsequent conviction, case number two, which has a guilty for trespass. And so then we have to analyze case number two. So trespass is one of the eligible JRA convictions, so we're good there. It has a 10-year waiting period. There's 1 year of jail time that this person received, so really it's 11 years. So we'd have to take a look at the next 11 years from 1995. So that would be 2006. This is the end of this client's record, so there's nothing there. So we can expunge both of these cases. These are both eligible under the new JRA expungement law. Are there any questions as to why that is? All right. And there's a good question here. The question was, do you have to serve the victim, or will the state do that? The court will serve both the victim and the state at the same time. So as long as you file the petitions with the court, they'll serve everybody who needs to be served. So there is no additional service required. It's a good question. Okay, let's take a look at another example client. This is a totally different client, so brand new record. So this client has 3 cases on their record. Case number 1 is from 1993, has a theft under $500, so it's a misdemeanor conviction. No jail time, no probation. Case number 2 has a conviction on possession and distribution. Looks like they got 1 year. And case number 3 from 2004, looks like they got a conviction from assault on assault second, no jail time, no probation. All right, let's go ahead and take a look here and analyze this client's record. So we see this case number 1, we see it's theft under 500. That's a misdemeanor theft conviction. That is one of the eligible convictions under the JRA. They got a guilty, there's no jail time. So the rule is 10 years is what we have to look at to see if they have a subsequent conviction from 1993, which is the date of disposition. So we take a look, that's between 1993 and 2003. Do they have another case? Unfortunately, they do. Case number 2 is from 1995, just 2 years later. They received a guilty on CDS possession, not marijuana, which is one of the eligible convictions, but they've also received a guilty on CDS distribution. CDS distribution is not one of the eligible convictions under the JRA. It is only possession. So unfortunately, case number 2 is not eligible for expungement, not eligible ever, unless you somehow were able to receive a pardon from the governor. Case number 2 is on your record forever. It's never going to become eligible. So because case number 2 will never become eligible, you cannot get case number 1 expunged. It is a subsequent conviction that locks in case number 1. So unfortunately, we're out of luck. If we take a look at case number 3 from 2004, we see it's a guilty on assault second. Assault second is one of the eligible convictions under the JRA. But as we remember from our slides, assault second has a 15-year waiting period. And so we have to take a look at the next 15 years. And unfortunately, we haven't yet reached current 15 years later. That would be 2019. So unfortunately, not enough time yet has passed for case number 3 to be expunged. But we'll note there's no other cases after that. So as long as the client doesn't pick up another conviction between now and 2019, we will be able to get case number 3 expunged. So if this client sat in front of me, unfortunately, there'd be nothing we could do for them today. But I would say, put a reminder in your phone, come back 2019, don't get in trouble until then, and we will expunge your assault second conviction then. Are there any questions as to why we weren't able to expunge anything? We have a question here. Are shielding provisions applicable to case number 2? Unfortunately not. CDS distribution is not one of the eligible convictions for shielding, and so it would not come into effect. And unfortunately, I had to look this up the other day myself to see if it was applicable. In regular expungement law, if you have a probation before judgment and there's a subsequent conviction, if you're able to get that subsequent conviction shielded, you can get that probation before judgment expunged. There's actually a line in the shielding statute that says that. There isn't a change to the shielding statute that says the same thing for this JRA expungement statute, which means even if you were able to get case number 2 shielded, I think legally under the law, you probably still wouldn't be able to get case number 1 expunged, because it is still a subsequent conviction, even though it's been shielded. And so I think it's something that probably got overlooked in the legislation. Okay, there's another question here, but can you repeat about how something with shielding can help with an expungement? So from my analysis of the statute, the shielding statute, it won't help with JRA expungements. There is a very limited situation where shielding a case can help with regular expungements in the case of probation before judgment. So as we all remember, if you have a probation before judgment, this is regular expungement law, not JRA. If you have a probation before judgment, you need to look at the next 3 years to see if there's a subsequent conviction. If there is a subsequent conviction on a probation before judgment, usually it's locked in, right? You can't get that PBJ expunged. However, if that subsequent conviction is for something that is eligible for shielding, like CDS possession, driving on a suspended license, there's 1 or 2 others, trespass is one of them, and you're able to get that shielded, then it no longer counts. The statute actually says it no longer counts as a subsequent conviction for a probation before judgment case under the statute. And so then you would be able to go back and expunge that original probation before judgment. So it's kind of it's a very narrow set of circumstances that would allow you to do that. And I looked it up because I was hopeful that shielding something would allow you to get something expunged because of the long 10 years under the JRA, and unfortunately they haven't changed it. The shielding statute specifically goes out of its way to say it no longer counts as a subsequent conviction for 10-105, which is the regular expungement law. I know that's very confusing, but it's for a very small niche area of expungement there. Okay, so there's two big changes coming to the forms. The old expungement form under regular expungement law is going away. There's now going to be two different forms. One form for cases where there aren't any convictions in the case, and one form for cases that contain even one conviction but is eligible under either one of the laws. And I'll go into what that means. The other big change is the fee structure. So for the most part, you've probably all taken cases on behalf of MBLS or HPRP and had the fee, the $30 filing fee waived because of an MLSC funded organization, and we've already checked the income. The fee structure, however, is normally $30 a case. They're changing that. If you're trying to expunge a case where you were not found guilty on any of the charges, there is no fee for that anymore. There is still the fee if you're trying to expunge a case where you were convicted of something in that case. And I'll go over what that means, but this should be a huge benefit for clients filing pro se or something like that. There's a question here, is there a fee for a probation before judgment? If that's the worst disposition in a case, then no. Probation before judgment is not considered a conviction, so you'd be fine there. Okay, so here's what the no convictions form looks like. You know, if you're used to expungement law, it looks very similar to the normal expungement statute. What they've done, though, is they've taken out all of the check marks that apply to convictions. This form only has check boxes for things like acquittal, dismissal, probation before judgment, null pros, debts, things like that. There are no convictions. So you are going to have to make sure that you're using the right form in the future when you try to expunge a case. So here is the form for convictions. You'll notice it looks very similar, except it says at the top, very top of the petition, guilty disposition. Now, this form is required not only for the Justice Reinvestment Act convictions, which only deals with convictions, right? So if you're trying to expunge anything under the JRA, you're going to use this form. It also applies to the limited set of circumstances where you can expunge a conviction under the normal regular expungement law 10-105. And those two, just as a refresher, are crime which are no longer a crime, which is pretty much just marijuana possession, and nuisance crimes. If you're convicted of one of those, it's eligible for expungement, you know, as long as certain circumstances are met. If it's one of those, you would file it on this form. And so if you're dealing with a case with a conviction, you file under this form, regardless if it's under the JRA or under the old expungement law. I see there's a question here. Does the fee policy change on 10-1? That is my understanding, is that this all goes into effect on October 1st. Okay, so that is the Justice Reinvestment Act. I see there's one more here. For previous MBLS clients that have charges that are now eligible for expungement, but were not before October 1st, what should we do? It's a good question. If they're previous MBLS clients that you have closed out, they're no longer clients of yours, you're free to kind of recontact them and tell them, hey, there's something that's now eligible. They would have to reapply for services. We'd have to recheck their income and go that route. But if you would like to volunteer and take up that case again, we'd be happy to do that for you. But there is no obligation to automatically take back and review and take all of the clients that you previously have had. Although I've been keeping a long list of all of my clients who have something that will become eligible on October 1st, I'm going to reach out to them and let them know. Joni has a good question. What about the app and the JRA? So MD Expungement will be up and running and we'll have the new forms by the time October 1st rolls around. And so it will do the analysis for you. It'll see if there's a conviction. It'll see if the conviction is one of the JRA expungements, eligible expungements, and it'll use the right forms. But because it's relatively new, I would just make sure that everybody double checks that the right form is printing and all the right checkboxes are being checked. But MD Expungement will keep up with the times, and we'll have the new forms and add in the new law as well. Now, MD Expungement has never been able to do subsequent conviction checking. It's only individual cases that MD Expungement is capable of looking at. So you are still going to have to go back, take a look at the next 10 or 15 years of that person's record to determine if there's any subsequent convictions. If you determine that there aren't any, then you can print the form, but MD Expungement won't be able to check that, unfortunately. And that has to do with case search, misspelling names and dates of birth, and it's very difficult to write a computer program to take all of that into effect very reliably. All right, let's see. There's another question here. Did you say that if an old client contacts us, they have to go back through MBLS to make sure they are income eligible? Yes, once we close a client's case, that effectively ends our representation. So if they'd like representation again, they do have to reapply for services. We don't just kind of have their case open indefinitely every time the law changes. So they would have to reapply. But if you're interested in taking one of your old clients back because they now have something that may be eligible, feel free to shoot me an email or Michelle Swift an email, and we'll go ahead and fast track that to connect you to make sure that all the T's are crossed. Are the paper applications available before 10/1/17? They are, but they're available with a big giant stamp over it that says do not distribute before 10/1. So you can't actually fill them out until October 1st. In an email that goes out after this, I will send a link to the expungement forms, the new expungement forms, so you can take a look at them. But unfortunately, the court has put a big stamp over it, so you can't actually print them out or start using them yet. Any other questions here? Perfect. So there are a number of ways to volunteer. We have clinics coming up. There's one in November here in Baltimore City that you can volunteer at. And that'll, of course, be after October 1st, so the new law will be in effect. We also have clients that apply for services just by calling our hotline or applying online, and we always need to place those clients with attorneys. And those you can sit down and correspond by mail or meet at your offices or Starbucks or whatever you may have. And then we also have a third way to volunteer, where we have a number of attorneys who volunteer at clinics, but for legal reasons can't actually be the attorney of record for an expungement. For those people, we take the petitions back and we have to place them with a volunteer attorney. And this can be a great way. All you have to do is review the petitions, make sure they're accurate, and then sign your name to them as the attorney of record and file them. And so it can be a way to, especially if you have a very hectic schedule, you might not be able to coordinate with clients or come to a clinic. This can be a way to still volunteer, give back, and help out doing some expungements in the process. So that's the new JRA expungement law that takes effect on October 1st. I'll send around an email after this with a bunch of resources, a link and a PDF to the presentation, and a link to all of the convictions on our website so you can review them. If you have any individual questions, I'm more than happy to answer them. Feel free to shoot me an email, give me a call. And if you have any kind of hypotheticals of what would happen, please let me know. I'd love to think through them with you and see if we can find some interesting ways to expunge more cases on somebody's record. All right, thanks so much. I'll stick around for a little bit longer if anybody else has any other questions. But other than that, you're free to go.